Welcome to the session on GDPR implementation for HR. In this session, we'll cover what is GDPR and what is the impact of those regulations. We'll also have a look at how this applies to you and what we need to do. We'll consider some of the actions and give you contact details if you require more information. So what is GDPR? GDPR stands for General Data Protection Regulations, and this became directly applicable to all EU member states on the 25th of May 2018. So this means that this applies to QB's operations in the UK, Ireland and France, as well as to our activities in other EU member states. The GDPR will be incorporated into UK domestic law by the Data Protection Bill, and this is regardless of the outcome of Brexit negotiations. An individual has a fundamental right to have their personal data protected, and their personal data may only be processed under certain circumstances. By processed, we mean obtained, recorded, held, used, or disclosed. The aim of GDPR is to ensure good information handling practice, and the requirements for compliance are much more stringent than under the previous data protection laws, and the penalties for failure to comply are much more severe. As previously mentioned, GDPR relates to personal data, and this means any data relating to any living individual who can be identified from that data. As a group, QB must be able to demonstrate compliance by showing the supervisory body evidence of internal policies and controls, implementation of those policies, effective internal compliance measures, and also external controls. Failure to demonstrate compliance can result in a fine of €20 million or 4% of the group turnover. And we must also be able to show an organisational culture that encourages compliance. So how does this apply to the HR team at QB? HR are responsible for the gathering and processing of the majority of personal data held by QB. This includes data on potential recruits, current employees, agency workers and former employees, and this will be known collectively as people data. Under the QB GDPR policy, the HR team will be held responsible for the collection, processing, storage and deletion of all people data across the business. If HR releases people data to others within the business, steps should be taken to anonymise the data. So consider, does the recipient need all of the personal data? You should remind the recipient that it is personal data and should not be printed out or stored on a local hard drive. And you should remind the recipient to delete the personal data once it is no longer required. So what do we need to do? From the 25th of May, we must have reviewed existing procedures. So we need to consider on what basis are we currently processing data and what consent do we have. We need to have a written map GDPR register showing where and how we process data and on what basis. We must be able to demonstrate consent and ensure individuals can withdraw consent at any time. We must have updated privacy policies, so we may have different policies for different activities. We must be able to respond quickly to a data subject request. That is, an individual can request for a copy of all the data held on them, or they may even ask for all the personal data held to be erased. We must be able to notify supervisory authorities within 72 hours of a data breach. And we must have a written information security programme protecting security, confidentiality and integrity of personal data. What data does HR hold? From completing the GDPR register, we know that HR holds a range of categories of personal data. Within personal data, the following data is considered particularly sensitive and may be called sensitive personal data or special category personal data. This includes race, religion, biometrics, trade union membership, ethnic origin, sexual orientation, health, politics, genetics, and sex life. This also applies to the processing of criminal convictions information. Do we have the right to process the data that we hold? In order to process personal data, we must have a right to do so, and the right can arise as follows: that the employee has already made the data public, or that processing is necessary for carrying out employment rights and obligations, and the employer has an appropriate policy document in place, or to protect the vital interests of the employee or another person, and the employee is incapable of giving consent, or for establishing, exercising or defending legal claims, or for reasons of substantial public interest, including archiving purposes and the processing of personal data which reveals race, religious belief, health or sexual orientation for the purposes of promoting equality of treatment, and the employer has an appropriate policy document in place. And finally, for the assessment of the employee's working capacity, either on the basis of domestic law or pursuant to a contract with a health professional and subject to confidentiality safeguards. Considering consent, in general, the best route for ensuring the right to process data is to have consent. However, this is not always possible in the employment relationship, as consent must be freely given. In France, consent by an employee to an employer is not considered as being freely given due to the unequal balance of power. As such, we cannot rely on consent and must rely on another ground. In the UK and Ireland, the relevant supervisory bodies have queried whether consent would be freely given in this context, particularly where the employee has no realistic alternative choice. In relation to our people data, we should not rely on consent. Here are some actions when considering consent. Review every item of personal data we are asking our employees to provide, and consider if it is strictly necessary that we have this information. If so, why? Under which implied right to process are we allowed to process that data? We should reduce the data we're holding to that which we strictly need and can justify. And we need to note that equal opportunities data is often the most sensitive. We must have a written equal opportunities policy, and we must only use that data for that purpose. If we don't, we should not be collecting the data. There are some more actions to consider. You need to review the data collection procedures. So do we need to hold all of the categories of data? And if not, we should remove them from our data collection process. You need to store data centrally on the approved IT system, so no personal data should be stored locally. Avoid producing paper copies of personal data. If it is necessary, ensure that they are kept securely and destroyed as soon as possible. Paper copies should not be taken outside of the QB premises and should be disposed of in confidential waste. If you have personal data visible on your screen, lock your screen before you step away from it. If people data is being shared by HR within the business, so for example to line managers, you need to share the minimum data necessary and consider if this data can be anonymised. Some actions relate to the recruitment process. Here you need to prepare a new applicant privacy notice. You need to incorporate that privacy notice into recruitment procedures. You need to store applications securely with restricted access, and this is to be controlled by HR and IT. Where applications and CVs are provided to line managers for consideration, you should remove any non-essential personal data, so for example addresses, email address, telephone numbers, date of birth and marital status. You should adopt a standard process for providing applicant data to line managers and remind them that hard copies of applications must not be left in public places, including on top of their desks. Hard copies must be destroyed in confidential waste after each interview, and not to store copies of applicant data locally. After the role has been filled, They should delete, destroy copies of all applications received, and HR should adopt the same procedures. Some actions relate to new joiners. Where a role is offered, the offer letter should be sent out by HR. Personal data of the applicant, so for example the address and telephone number, should not be provided to line managers unless the applicant has consented. Application details may be retained as part of the employee record, and you need to review the new joiner pack and confirm that we need all of the information we are currently requesting and can justify the need. You need to include an employee privacy notice with new joiner packs and ensure that this is signed. You need to ensure new joiners are provided with access to all relevant company policies, including the CCTV policy and the GDPR policy, and are asked to read them. You should obtain written evidence they have received the policies. And finally, you should ensure all information received from new joiners as part of onboarding is securely saved in electronic copy. Hard copies of original documents should be retained for legal purposes, but they must be in a locked cabinet with restricted access. Some actions relate to existing employees. So details in relation to existing employees should be kept securely and controlled by HR. Employees' personal data should not be released outside of HR unless strictly necessary. Line managers should not have copies of employees' personal contact information without the employee's consent. Details of training records, appraisals and performance reviews should be controlled and securely stored by HR. You should ensure existing employees are provided with details of any updated policies. When dealing with employee data, it is possible that in some instances we want to share personal data within the business that deals with a number of employees. In this case, we need to consider if we can aggregate the data to make it more anonymous. Or can we anonymise the data? So is it really necessary to send data with individuals' names and details included? And if we are discussing an employee issue within the wider business, is it necessary to name the individual, or can that be avoided? For former employees, when employees leave the business, we have a legitimate right to retain the employee records for 6 years, as they may bring a claim against us. In terms of payroll or tax information, the period may be slightly longer. Former employees' data should not be accessible by line managers and should be controlled by HR and IT. It should only be accessed to the extent required by a regulatory body such as HMRC, or in the event of a claim by the employee, or in limited circumstances by a third party, or in the event of a subject access request. At the end of the retention period, the data must be destroyed. If you are dealing with a subject access request, it's important to consider that an individual has the right to obtain information as to whether or not personal data is being processed about him or her. We also need to remember that if personal data is being processed, the individual is entitled to be given a copy of his or her personal data together with the following information: the purpose of the processing, the categories of personal data concerned, the recipients or categories of recipients to whom data has been or will be disclosed, the period during which personal data will be retained, information on the source of the data, any information regarding complaints and disputes, the right to complain to a supervisory authority, the right to request rectification or erasure of personal data, and to object to processing of data or to restrict that processing, and where the personal data is transferred outside of the EEA, information on any Article 46 safeguards. The information must be provided free of charge, and the data controller must provide the information summarised above without undue delay and in any event within 1 month of receipt of the request. There are some actions that relate to policies and processes. You need to review your existing policies and processes within the team to ensure that they reflect GDPR requirements, and any new policies, procedures or activities that you are planning should reflect privacy by design, with GDPR being a principal driver in how that policy or procedure is designed and developed. To the extent that we're collecting personal data about contractors and agency workers, the same rules apply. In particular, we will need to obtain a signed privacy notice confirming what information we'll be processing and the justification. This will need to be a different document to that used for our employees, as we will process less data. They must also be made aware of CCTV and GDPR policies. Who to contact for more information? If you have any questions or you would like more information, you should contact your line manager in the first instance, or you could contact your HR business partners, Lauren and Philippa, and they can be contacted on the emails below. Thank you for watching the session on GDPR.